Welcome back. It's an honor for me to introduce Megan Flynn, member of the Washington & Lee Law Class of 2014, who is the recipient of the Roy L. Steinheimer Law Review Award for her note entitled A Continuing War with Asbestos, the Stalemate Among State Courts on Liability for Take-Home Asbestos Exposure. I should say this distinguished award that Megan received is named for the W&L Law Dean from 1968 to 1983, Roy Steinheimer, whose portrait is right outside this door. So on your way out, take a look. Now, Megan Flynn is a 2011 graduate of West Virginia University, where she compiled an extraordinary record. She was elected to Phi Beta Kappa. She graduated summa cum laude with majors in mathematics and philosophy. She was selected to present her senior thesis at WVU's in-house philosophy conference in 2011. She was a WVU Honors Scholar, one of 83 students in the country to receive a Geico National Achievement Award. She was president of the Alpha Lambda Delta National Honor Society. She was also involved in Relay for Life. At Washington & Lee, she is now a student extern for Judge Robert B. King of the U.S. Court of Appeals for the Fourth Circuit. She has been a summer associate at Jackson Kelly in Charleston and at KML Gates in Washington, D.C. After graduation, she will clerk for the Honorable Joseph R. Goodwin of the U.S. District for the Southern District of West Virginia. And for all of us who are such fans of Judge Goodwin, we are particularly thrilled that Megan will be working with him. After the clerkship, she plans to go back to KML Gates in Washington. And remember, what she's got to do, though, this year is be executive editor of our law reviews. So, now, Professor Jost, who's here, Professor Jost and I were advisors to Megan on her note. I can safely say that both Professor Jost and I marveled at her exceptional abilities and exceptional dedication to the project that she will present in a minute. I often recommend to students that they write notes about the common law and about torts. And I was so glad that Megan was already interested in this before she came to talk to me. And already interested in all the issues concerning asbestosis. And then she proceeded so smartly to narrow the topic by selecting the whole field of take-home exposure. From the beginning, she was interested in proposing a concrete solution. And she worked like the best of scholars inductively, digging deeply into the cases one at a time, to discern the duty problem clearly and gradually to formulate a practical response. It was exciting for me, and I know for Professor Jost, to watch her progress and to see her mind so actively and energetically engaged. And it was particularly exciting to see how she also delved deeply into very current debates on the nature of duty and tort law. Now, we're in for an even more special treat because commenting on Megan's paper are two individuals who are well known in the world of legal scholarship, but are also very well and affectionately known in the community of Washington & Lee. First is Professor Jill Fraley, who's now in her third year as a member of the W&L Law faculty. And I may be getting the order wrong here, but let me introduce Professor Fraley first. She's a popular and respected teacher here of property, environmental law, law and geography, legal history. Recent writings of Professor Fraley focus on the legal history of Appalachia, on property theory, on numerous other topics. She's a 1999 graduate of Yale College, a 2002 graduate of Duke University School of Law. She practiced law for more than 6 years, working primarily in the areas of toxic torts and premises liability, and returned to Yale to obtain an LLM degree in 2008 and a JSD degree in 2011. So it's a thrill to have Professor Fraley commenting today. Joining her is David F. Partlett, the Asa Griggs Candler Professor of Law at Emory Law School. Now, most of you don't know this, but Professor Partlett served as Dean of Emory Law from 2006 to 2011, and before that he was vice president and dean of the law school at Washington and Lee. He served as dean of our law school for 6 years, 2000 to 2006. This beautiful new courtroom and our beautiful classrooms are part of Dean Partlett's legacy. In his time here, he also increased the size of the faculty and expanded our international curriculum, among many other things. He's a noted scholar and teacher of torts, professional liability, and remedies. A native of Australia, he earned his LLB degree from the University of Sydney School of Law and advanced degrees at Michigan Law School and at UVA. Before coming to W&L, he was on the faculties at Vanderbilt with Professor Howard and the Australian National University. In the Australian government, he was a senior legal officer on issues relating to human rights and to racial discrimination. He was a member of the Australian Law Reform Commission, and in this country he's a member of the American Law Institute. He's written books on torts, and the two that are particularly on my shelf, he is the current author of the Prosser case book on torts, and co-author of a book I've read more than once called The Right to Speak Ill. Love the title. Reputation, Defamation, Free Speech. Anyway, it's a pleasure to have both Professor Fraley and Dean Partlet with us. So now, let's hear from Megan Flynn.
Hello, everybody, and thank you all for being here. I'm really honored to have received this award for my note and to be here representing the Law Review. And thanks to Professor Murchison for that great introduction, and also Professor Jost over here, who came to be here today. Both of them were advisors to my note, and I had the pleasure of being in a class with each of them. And they're brilliant professors, and really I'm just so honored to have them guide me in my note. And thank you both for being here today. Professor Murchison's introduction of my commenter just makes me amazed that they came to talk here today. Professor Partlet returned to W&L from Emory, and he has, like Professor Murchison said, has a long history with the law school, and I'm honored to have him comment on my work. And Professor Fraley, not only is she here commenting on my note, she was my W&L legal writing professor. So I tried to apply what she taught me in my note, and hopefully I made her proud. And finally, I want to thank my family and my boyfriend Aaron and my friends for all being here today. They've heard me talk about asbestos for about a year now. So, and then they traveled 3 hours to hear me talk about it for 20 more minutes. So either they're really excited about asbestos litigation or they love me. And I hope it's the latter. As Professor Murchison said, my note's about take-home asbestos litigation. Asbestos is a natural mineral composed of fibers with special physical and chemical characteristics that make it very useful for industrial work. And workers began using asbestos in the early 1900s for manufacturing, shipbuilding, insulation, and auto mechanics. It's in brakes, it's in walls, ceilings, it's still found in old buildings, even now. And now, but much too late, we know about the extreme toxicity of asbestos. Exposure to asbestos, and by exposure I mean inhalation of the fibers and dust. It's kind of like if you're sanding a piece of wood and the wood particles fly in the air. That's what happens when you're using asbestos. So when someone would inhale these, it increases the risk of lung cancer, mesothelioma, which is a cancer of the lining of the chest cavity, and asbestosis, which is a lung disorder. And most of us have been aware of the dangers of asbestos for most of our lives. We've all heard the commercials. If you or someone you know have been a victim of mesothelioma. So it's kind of a common thing. But we might not realize the disastrous and unprecedented impact that asbestos has had on the nation and the impact that it continues to have. In many ways, the problems caused by asbestos are closer to the beginning than the end due to the latent effects that asbestos has on the body. I know that when I began my research, I was astounded by some of the statistics. Asbestos causes illnesses for 10,000 people per year. Asbestos will kill as many as 265,000 people by the year 2015. Asbestos resulted in over $70 billion spent in litigation costs through 2002. and asbestos is a source of over 400 pending cases in Delaware alone as of October last year. And a quote by Justice Ginsburg is very illustrative, I think. A tale of danger known in the 1930s, exposure inflicted upon millions of Americans in the 1940s and 1950s, injuries that began to take their toll in the 1960s, and a flood of lawsuits beginning in the 1970s. Now, most of the litigation up to the 1990s came from the workers themselves who were exposed to asbestos. Now, as quoted by scholar Victor Schwartz, the war is still being waged, but the battlegrounds have shifted to new issues. Asbestos litigation has moved beyond claims by industrial workers and into claims made by their family members. These family members bring claims of take-home asbestos exposure. So this slide, please forgive the crude illustration after Kyle's Yoda video. But this kind of shows the typical case of take-home asbestos. So it describes a wife who claims she contracted mesothelioma from exposure to asbestos while washing her husband's work clothes. So her husband might have worked as a shipbuilder or an asbestos factory or an insulation warehouse, and he would wear his clothes home, his dirty clothes home, and his wife would shake them out in preparing for washing them. And the dust and fibers on the clothes would fly into the air, and she would inhale that dust day after day, year after year. And decades later, after her husband had probably died of mesothelioma himself, the wife would then discover that she'd also contracted the disease. She would sue her husband's employer for negligence. She would claim that the employer knew or should have known about the dangers of take-home asbestos, and the employer should have prevented those dangers by providing a washroom on the premises of the factory or by warning the workers' family members. So dozens and dozens of take-home asbestos exposure cases sprouted all over the country beginning in the 1990s, and they're still coming up now. The state's courts are all deciding these cases different ways, resulting in recovery for a victim who brought his case in Louisiana, for example, and no recovery for a similar victim who might have brought his case in California, for example. Some state courts determined that the employer had a duty to protect the family member of employees, while other states decided the employer did not have such a duty. So I looked at this split in case law, and I asked, should an employer have to compensate these victims of take-home asbestos? Does the employer owe a legal duty to the family members who were infected by asbestos on employees' work clothing? I struggled with the answer. On one hand, I do believe in the tort system. If an employer's use of asbestos led to a worker's wife contracting mesothelioma, it seems that that employer should make the injured person whole again. But on the other hand, how far can we move the line of liability? Should an employer have to bear the consequences of this chain of events of which she was unaware? I decided the answer to this question is the same as the answer to all questions we confront in law school, and that is, it depends. Before I reveal my proposed analysis for take-home asbestos cases, I want to outline the different ways that state courts have approached this issue. And the states fall into three different categories of analysis for determining legal duty owed to victims of take-home asbestos. First, there's analysis based on foreseeability of harm. Second is analysis based on the relationship, that is between the defendant employer and the plaintiff family member. And third, there's analysis based on the second restatement, which differentiates between nonfeasance and misfeasance. So first, foreseeability. Courts using foreseeability of harm to determine the legal duty in take-home asbestos cases ask, did the defendant, the employer, know or should he have known about the dangers of take-home exposure to asbestos at the time of the plaintiff's exposure? The courts use the testimony of experts as well as federal regulations that existed at the time to make this determination. If the defendant should have known of these dangers of take-home asbestos, then he owes a duty. But if at the time he would not have known of these dangers, then no duty would exist. The problem with this approach, however, is that differing accounts exist about when the asbestos industry became aware of take-home asbestos exposure. The second type of analysis considers the relationship between the defendant and the plaintiff or lack thereof. Courts in this category often utilize balancing tests, weighing various factors such as foreseeability of harm or burden on the parties to determine whether a duty exists in a specific case. Though each court does not use the same factors in its analysis, all courts predominantly focus on relationship. And that's legally significant relationship. So an employer would have a legally significant relationship to an employee, as would a lawyer to his client or a doctor to her patient. But does an employer have this similar kind of legally significant relationship with an employee's wife, especially when she's never been to the workplace, been on the premises where asbestos was located? In answering this question, the courts in this category often look at public policy considerations. Most courts determine that finding a relationship and a duty in this instance would be simply too great. The courts fear the consequences of extending a premises owner's duty to anybody who comes into contact with someone who's been on the landowner's property. They worry that imposing such a duty might create a potentially limitless pool of plaintiffs. They call this the specter of limitless liability. So it's essentially a slippery slope argument. And the third approach is the second restatement, which distinguishes between misfeasance and nonfeasance. Anyone who commits misfeasance, an affirmative act, has a duty to exercise the care of a reasonable man when his actions have put another at risk. One who is negligent by nonfeasance, omission of an act, has a duty to protect another only when there's a special relationship between the actor and the person he injured. So the question for these courts becomes, did the employer affirmatively act in a way that led to the plaintiff's asbestos injury, or did the employer merely omit to act, in which case he would not be liable? I'm going to tell you the story about a case called Satterfield against Breeding Insulation Company, and it's from the Supreme Court of Tennessee. And not only does it illustrate the second restatement approach, but it also is a really heart-wrenching example of take-home asbestos. The plaintiff in this case was the daughter of an employee who worked at a factory containing high levels of asbestos. The plaintiff was born prematurely, and she spent the first 3 months of her life hospitalized. Her father, Mr. Satterfield, would visit the hospital every day after work without changing out of his asbestos-contaminated clothing, and therefore he exposed his daughter to asbestos literally from the first day of her birth. The plaintiff contracted mesothelioma and sued her father's employer for negligently permitting her father to wear his asbestos-contaminated work clothes home from work, and the daughter died of mesothelioma at the age of 25. The father continued the suit, and the Supreme Court of Tennessee characterized the defendant's conduct as misfeasance. The court stated that the employer committed the injurious affirmative act of operating its facility in such an unsafe manner that dangerous asbestos fibers were transmitted outside the facility to others who came in regular and extended contact with the asbestos-contaminated work clothes of its employees. The court looked at the policy concerns that I mentioned before, namely the specter of limitless liability, but these did not dissuade the court. So as you can see from the summary, there's no single way for courts to approach the take-home asbestos issue. There's no consistent precedent, and courts handling this issue for the first time have no guidance. So my goal for this note was to provide a method by which courts could handle take-home asbestos cases to create consistency in outcome. I first looked at some proposals that others have offered. One proposal for courts facing take-home asbestos cases comes from Section 7 of the Third Restatement of Torts. Section 7 states that if there is causation between the defendant's act and the plaintiff's harm, the court should presume the existence of duty. Courts should depart from this presumption and refuse to find a duty only for public policy reasons. Although many courts consider foreseeability in determining duty, Section 7 makes clear that foreseeability should have no role in the judge's analysis of duty. Only an articulated, countervailing principle or policy could support a judge's no-duty decision. Without such a principle or policy, the court should hold that a duty does exist. So under this approach, every employer in take-home asbestos cases would presumptively owe a duty to the family members. Supporters of Section 7 contend that presuming a duty exists and removing foreseeability analysis from the court will result in clear precedents. Supporters also emphasize that Section 7's approach to duty allows for greater transparency in courts' decision-making. Instead of disguising their policy decisions in legal terms like foreseeability, the court can explicitly state their policy concerns that are truly motivating their decisions. There's critics of Section 7 as well. First, eliminating foreseeability of duty analysis contradicts the predominant judicial approach. Almost every jurisdiction, 45, the last time I checked, considers foreseeability in its duty determination. Section 7, however, ignores this near-unanimous judicial use of foreseeability. Second, while the Third Restatement suggests that courts turn away from foreseeability and toward policy considerations, oftentimes, to arrive at a policy decision in the first place, a court must still engage in questions of foreseeability of harm. So I looked at this proposal for duty determination, and I asked whether Section 7 of the Third Restatement could be applied to take-home asbestos cases. I argued that Section 7's approach to duty is not a satisfactory solution to the divergence of outcomes in take-home asbestos cases. First, Section 7 does not work within the usual procedural posture of take-home asbestos cases. Almost always, these cases arise under a defendant's motion for summary judgment. He argues that he owes no duty to the plaintiff, so the case should end. If the trial court agrees with the defendant and grants the motion for summary judgment, the case closes. So the motion for summary judgment serves as a tool for a court to eliminate unnecessary litigation and avoid unwarranted loss of resources. Given the tens of billions of dollars already spent in asbestos litigation, a court's analysis of take-home asbestos should embrace this purpose of summary judgment. But Section 7 does not allow this. On a motion for summary judgment based on lack of duty, Section 7 requires the court to presume the existence of duty, allowing the case to continue, or dismiss the motion, unless the court would want to wrestle with policy determinations. As such, a motion for summary judgment centered on the absence of duty will succeed only in exceptional cases. In fact, each court that has applied Section 7 to review motions for summary judgment has denied the motion and has sent the case to the jury. Section 7, therefore, undermines the purpose of summary judgment, which is to assess the proof in order to see whether there is a genuine need for trial. By requiring the court to presume duty, Section 7 bars courts from reviewing the record for a genuine issue of material fact on the existence of duty and limits the court to policy considerations. But if courts can use foreseeability in their review of motions for summary judgment, they can better identify the cases that do require a jury's consideration. This is especially true for take-home asbestos cases, in which the existence of duty frequently depends on the date on which the plaintiff's exposure occurred. If a judge can make this determination based on the facts entered with a motion for summary judgment, then she should be able to grade the motion without considering policy. Second, Section 7's requirement that courts engage in public policy considerations before making a no-duty decision is problematic because these cases often involve competing social policies. On one hand, extending an employer's duty to the failing member of his employees will lead to a potentially boundless number of plaintiffs, the specter of limitless liability. But on the other hand, society would benefit from ensuring that corporations are held accountable for the consequences of their processes. After all, asbestos has caused what is considered the worst occupational health disaster in U.S. history. Arguably, courts are not the most competent body to decide which policy consideration should prevail. Because Section 7 insists that courts support their no-duty decisions and public policy rationales, it's not the best approach to these cases. So what is the best approach? Essentially, the differences in holdings on the existence of duty in these cases comes down to courts' presidential common law of torts. Some cases principally focus on foreseeability, others focus on relationship. Section 7 fails to take into account the reality that states do not weigh factors in the same manner. I argue that a multi-factor test most appropriately handles take-home asbestos exposure cases. The balancing test allows courts to weigh factors in accordance with their body of common law while maintaining sufficient uniformity throughout the country. The relevant considerations vary among the states for these cases, but courts commonly hold 4 specific factors as important in duty analysis: foreseeability, relationships between the party, the burden that creating a duty will place on the defendant, and public policy considerations. The benefits of such a balancing test are as follows. First, maintaining foreseeability of harm as a factor conforms to the practice of most states. Placing the foreseeability factor within a balancing test allows each state to assess it in accordance with its tort law, rather than eliminating foreseeability as a factor altogether, as Section 7 does. Second, even if a court did not heavily weigh the foreseeability of harm, preserving it as a factor allows courts to quickly eliminate factually deficient cases at summary judgment. Courts can use foreseeability of harm to eliminate the easy cases, leaving more difficult cases for the jury. If there was no harm that was foreseeable at the time, there would be no duty and the case would end. So this approach supports the goals of summary judgment, to wisely manage judicial resources. Finally, the multi-factor test supports Section 7's public policy evaluation and duty analysis. Making public policy an explicit prong in a factor test addresses the concern with lack of transparency in judicial decisions. And allowing flexibility within this 4-pronged structure ensures that states can conform to its negligence jurisprudence while bringing uniformity to duty analysis nationwide. And while this multi-factor test can help courts now, I ultimately argue that the only way a state can ensure complete consistency in this area is through legislative action. Because these cases implement competing public policies, elected government representatives, rather than judicial bodies, should decide which policy prevails. A number of states have statutorily responded to the issue of liability for injuries caused by take-home exposure to asbestos. Ohio and Kansas have statutorily eliminated any cause of action for victims of secondhand exposure who have not been on the premises of a landowner. I argue the state should pass legislation to control take-home asbestos litigation. Given states' varying public interests and the uneven distribution of asbestos claims throughout the nation, a state should tailor its statutory response to effectively address its own problems. All states have an interest in furthering the purpose of the tort system by compensating those who are injured by others. And state legislatures should be mindful of this purpose when considering the issues of take-home asbestos. But some states, such as Delaware, bear a large concentration of the nation's asbestos litigation. These states, therefore, have an interest in reducing asbestos lawsuits and purging this specter of limitless liability. As such, they might want to consider adopting a statutory response similar to Ohio's that serves as a complete bar to claims against landowners for asbestos injuries contracted by individuals who have never been on the premises. Alternatively, in states where asbestos litigation does not greatly burden the courts, the legislators can draft statutes that recognize the rarity of secondhand asbestos cases. The legislator should review literature on the history of asbestos and determine the date on which when the asbestos injury should have been aware of the risk of take-home asbestos exposure. Then the statute should allow compensation for exposure occurring after the date and bar compensation for exposure occurring prior to the date. And many courts already approach take-home asbestos exposure cases in this manner. A multi-factor test for the judiciary and proposed legislation for state legislatures allow the state and the nation as a whole to combat take-home asbestos exposure cases from two different forums. I hope that my note and its proposed solution could unify state courts, guide judges facing these cases on first impression, and bring peace to the victims of asbestos-caused illnesses. Thank you.
That was wonderful, and your comments reflected the power of your note. It's wonderful. And let me say that it's just great to be here amongst old friends, and I thank the law review and the particular organisers of the symposium for pulling all of this together, picking me up at the airport, carrying me around on a silk like a pasha. So it's all very interesting. It's wonderful. It rarely happens to me, I can tell you. So it's like coming home, and I feel very grateful. I was sitting down last night. I gave a class before I came this morning, and Anne Massey was carrying around some old notes with her. I go through old notes, looking at what I'm going to say the next morning to my torts class. And what should I see scribbled in the corner was a note mentioned to students the note symposium tonight on medical malpractice standards, and it was dated the 17th of September 2003. So it somehow transported me back to that time, and it was wonderful. It's a great pleasure to comment on the paper. Megan took us through this asbestos material. It's a miracle material at one point. It was known to the ancients. And suddenly we see it's a toxic matter, and it's actually been Brian will know that once, if you labelled yourself a torts professor, you went to a cocktail party, and no one would be cleared the room. No one would want to talk to you. You're a torts professor. You were by definition a boring person because you dealt with boring law. And suddenly, all of this has changed in our lifetime in recent years, where you've got high-impact products. Most tort litigation and most of our problems in tort law are caused by just a handful of products. It's medical devices, drugs, motor vehicles, other toxic chemicals, and asbestos. And asbestos stands alone as the one substance that causes such problems in the health, death and morbidity of victims of asbestos, and it has created tremendous challenges for the tort system. What you have in asbestos are very telltale diseases, as we saw. So one can establish the causal link between one's exposure to asbestos and the resultant diseases, many of which lead to death. And all of these problems, asbestos being one, have been grafted onto a a tort system that was developed in medieval times to cope with quite simple interactions between people. And it accommodated itself to change circumstances in the Industrial Revolution, change circumstances throughout the 20th century, but has really run into tremendous barriers to effective court adjudication in recent times, and just trying to deal with the multiplicity of actions, the sheer volume of them, and the federal system that doesn't seem to be set up to accommodate all of the problems. You add on top of that the fact that we are dealing with diseases. Diseases were not really part of what the old common law looked at. It was accidents causing some physical injury, which was quite obvious. Now you've got diseases with long latency periods, and so you've got long-tail insurance problems when you've got insurance involved. So Megan does a wonderful job in looking at the way these claims are brought. She covers the case law with great thoroughness and precision. And she shows how the courts have struggled with the scope of the duty. She has some hope. I think it might be rather measured hope that perhaps legislatures will see some light here and come to aid. We can't be sure of that. I think that the latest effort by Congress on asbestos is called the FACT Bill, 2013, the Furthering of Asbestos Claims Transparency Act. Well, guess what this is about? This is one which is designed to try and control the trusts that have been set up to compensate victims and to weed out all sorts of fraud that is asserted to be exercised in this part. That's an assertion without any real fact behind it. Now, in the comment, I want to say a few words about the war on asbestos and the common law of torts. Certainly, I want to talk about this the problem of expanding liability. And thirdly, I want to add my pleas to Megan's in terms of what legislature should do to regulate the claims process. Talking about asbestos and the role of tort. And I want to emphasize something about the role of tort in information forcing. Asbestos was around for a long time, and there was a great deal of ignorance about it. Surprisingly, as we look at it now, we would think that we would know what the causal connections were, but there was a great deal of denial that asbestos caused injuries. And tort law has played an indispensable role. The litigation process has played an indispensable role in uncovering the causation, the etiology of these diseases, and labelling asbestos as the villain. Just as in the tobacco litigation, waged over many years, we saw that a positive role of tort law was to shine light on the industry, to show what injuries were really caused by it. So there's a question of, this may have been a costly process, but in the end, it has revealed this information. Then the challenge of the tort system is, having revealed that information, how can we properly adjudicate these large numbers of claims? And that's where the challenge has been, really, over the years. And that's where you would think that there might be a partnership between the legislature on the one hand and the courts on the other in coming together to try and solve this problem and put together some sensible framework. That we don't see. Secondly, I want to talk about the scope of the liability issue that Megan raises so well. The idea was, of course, is that asbestos litigation has been agonizing over many years, but now we see some light at the end of the tunnel. What should happen, however, to that light? Another freight train suddenly comes down, and it's the take-home asbestos problem. This gives rise to new possibilities of claims in the asbestos field, and there may be others that imagination doesn't run to right now. Is this surprising? No, it's not surprising. It's always been an issue. Once you open up liability anywhere, you are going to find some increased number of claims being brought. This was the great problem when tort law was being fashioned in the mid-19th century. In the great case of Winterbottom and Wright, Lord Alderson said, if one step, why not 50? If we find a duty of care, when are we going to stop? That was and he was very much pooh-poohed for this. This was something that was ridiculous, that he would be so conservative. Our students look at it these days and say, how did you say that? But it's true. There is new liability always being piled on. But then the great titans of tort law, Benjamin Cardozo and Lord Atkin in England, opened up liability. They said liability should run more broadly than just in pre-existing categories. What we need to have is a broad principle. What's the broad principle? In Lord Atkin's style, it was that you should owe a duty to your neighbour, relying on the parable of the Good Samaritan. Who is your neighbour? That person who will be foreseeably injured by your act. You owe that person duty of care. If you are negligent to that person, you will be liable to you. So the relationship idea there is this relationship that is the neighbour relationship. Benjamin Cardozo in the Macpherson case says, in broad terms, in a modern consumer society, as it was emerging at that point, we ought to have a broader idea of liability so that manufacturers who are negligent in the manufacture of their products and these cause injuries to consumers of these products, they're a Buick motor car, ought to be liable for those injuries in a broad way. And in Palsgraf, 13 years later, he says, let me put this explicitly in terms of foreseeability. It is, you owe a duty of care to all those persons who will be foreseeably injured as a result of your negligent act. So this opens up, this is hydraulic force. Where do you stop foreseeability? This is, so you had the justice on the California Supreme Court saying, on a clear day, the California Supreme Court can foresee forever. And it's true. There is no stopping the idea of foreseeability. Foreseeability is just not seeing that something is likely to occur. No, it wraps up a whole lot of other factors in it. And so, can there be any doubt in the take-home asbestos case that an employer charged with knowledge that asbestos is a toxic substance, causes these injuries, would know, or should have known, that if the clothes are taken home untreated, someone else will actually catch the disease. Who's most likely to catch the disease? It is the family of the worker. That's a relationship of neighbourhood, one would think. And so you would think, therefore, that there should be an extension of liability to that class of person. But, as Megan points out, it's a question of knowing where to stop. How do you confine or cabin the scope of liability? And we spend a lot of time in tort law. Everything you ever wanted to know, you learn or know, you learn in first year tort law. And not kindergarten, first year tort law. And so first year tort law, we go look at the idea of duty and we compare it with the idea of proximate cause. And we see that duty is, in fact, has the capacity to cut off liability where judges want to cut off that liability. And they can do so by way of summary judgment if they find that there's no duty of care owed in the circumstance. Now, what Megan does in a brilliant way is to navigate all of these cases, which go all over the place. This is really like Captain Cook heading off from England and finding Australia and finding all these other. going through shoals and sort of sharks, and it's really, really a complicated matter. It's even more complicated than this copyright. It's a terribly complicated story to tell, and he tells it brilliantly. It's it generally is completely messed up, and so how do you ever get a handle on this thing? I taught last semester at the University of Sydney, and I thought, oh well, perhaps they've solved the problem of how far liability should go, what the scope of liability should be. No, of course they haven't. But they've got a whole lot of cases that I had to sit down and read, about 100-page cases, about 20 of them, in order to try and relate to the students just where the limits of liability should be. I should have had actually Megan there read all these cases and relate to the students just how this should be. Now, where do we stop liability? How far do we go in finding this class of person is owed a duty of care? We could put it in terms of causation too. We could put it in terms of proximate causation and call that a legal matter also and solve that as law, although it tends to be more of a question of fact. And here, Cardozo and Andrews in Palsgrave fight with one another about this. But, you know, you could go through all of this, and as I was reading Megan's comment, and as I was sitting back thinking about the duty of care and growing very tired, I thought of T.S. Eliot and his observations about human experience, which I think apply to the duty of care. T.S. Eliot said, "We shall not cease from exploration, and the end of all our exploring will be to arrive where we started and know the place for the first time." Now, that picked me up rather. And I think that's true. I think you've got to, in the scope of the duty issue, think about how we've come through all of these cases. But there's a lot to be said for going back to those original cases and seeing what was said by the great judges. There's a very good observation, I think, from Michael Kirby of the Australian High Court in a case of Graham Barclay oysters. This was a case about 10 years ago. And the problem here was, what's the duty of care that you would impose upon these local authorities who are responsible for the cleanliness of lakes? The plaintiffs here had eaten oysters from these contaminated lakes. You want to bring an action, there's horrible consequences. And was there a duty of care owed by these local authorities to the ultimate consumers of the oysters? And Michael Kirby goes back to Oliver Wendell Holmes and says, well, Holmes had a few things to say about this. And then he looks at all of the Australian and English authorities and a couple of American authorities. And he says, you know, the search for a simple formula for determining the existence of a duty of care may indeed be a will-o'-the-wisp, as one English judge said. It may send those who pursue it around never-ending circles and ultimately bring the traveller back to the very point at which the journey began. Thus we seem to have returned to the fundamental test for imposing a duty of care, which arguably explains all of the attempts so far. That is, a duty of care will be imposed when it is reasonable in all the circumstances to do so. That is the test that I adopted with a fellow judge in another case called Tame, which was an emotional distress case. Even if the approach of the other members of the court to that case does not so implicitly, it's obvious that the touchstone for reasonableness is the fundamental to the way in which we should determine the existence or otherwise of the duty of care. So in the end, whether you look at Section 7 or whether you look at foreseeability, the approach there was, having navigated all of these cases and all of this, to somehow you've got to ground this in reasonableness. What does this mean? Well, it means a whole lot, all your factors really, including policy decisions or policy factors. And all of these have to be articulated by the court. So I think that's the way of it. Now, asbestos and the legislature. As I said at the outset, you know, the legislatures have let the victims of asbestos down badly in not really responding to the felt needs of the victims in having a proper adjudication process. As I was thinking about it, I thought of some legislation that in fact exists in New South Wales, the state of Australia, where a dust diseases tribunal was set up under legislation. This doesn't particularly solve your problem, but what it does is vest these claims in a body that has an expertise in adjudicating these matters. So they know all of this. You don't have to really educate the court anew every time on this matter. So that might be a way to go. Not sanguine about Congress especially, or some of our state legislatures in accepting your very good suggestions. Although I've got further hope that they will read your great comment and act upon it. I've been teaching torts for a long time, and back in the early 1980s I was teaching, and I was talking about asbestos cases and how they're emerging. And a student of mine who was in the class got up and came to see me after class. He said, you know, I grew up in a small asbestos mining town in the west of Australia. And the company would put out, we'd play, and they'd put out in the playground for us to play on blue asbestos. So we'd play in it, it would be a soft substance to play on. We've come a long way since then. We've had the education that the tort law has given us. It's shone light on it, and we've still got problems to solve. Great paper. Thank you very much.
First, I want to say thank you to the Law Review and also to Megan for this opportunity to comment on her paper. I am very honored to comment on Megan's paper. As she mentioned, she's one of my 1Ls, and I think everyone knows that I really adopt my 1Ls, and I really like to brag on them later, and Megan makes it really, really easy to do that, so I appreciate that a great deal. So in this comment, I want to take the opportunity to explain some additional support for the approach that Megan takes in this article, which rejects what a lot of people have sought in terms of a major nationally consistent effort to deal with these cases. In a way, what you could say is what I'm doing here is I'm justifying Megan's "it depends" answer, which may be exactly what you expect from a law professor, right? To justify the "it depends" answer. But I think the "it depends" answer is the right answer, and I'm going to tell you a little bit more about why. This article's approach may not have the simplicity of design or execution of a major national solution to these kinds of claims. However, there are significant reasons for pursuing solutions that are a lot more flexible and nuanced. And those reasons have a lot to do with history and a lot to do with geography. You might say that as a historian, I would argue that one of the answers that we have to that question of foreseeability is a historical answer. We ask the question of what people knew at the time and how they understood the toxicity of asbestos. There is a geography to asbestos use, to the distribution of asbestos products, and thus, therefore, also to the distribution of asbestos-related claims in the United States. Now, my own observations that I'm making in this particular moment come from direct experience, in the sense that when I litigated, I actually at one point was sent by a client to essentially engage in a historical expedition. I was given free rein in rooms with hundreds of boxes of documents dating back to the early parts of the 20th century. And I was asked by a very reputable company that cared about its own appearance in the media to figure out what they knew, because they didn't know the answer to that question. We can ask a knowledge question about a person enormously more easily than we can ask a knowledge question about a corporation. And this corporation honestly said to me, we're going to have to turn this stuff over in discovery. Would you please go figure this out? We know you have a degree in history besides your law degree. Why don't you go figure out what our story is so that we can decide, do we want to settle a lot of things up front? This was a company that was a new defendant in this type of litigation. They needed to know, do we want to settle things up front because we don't want to talk about our story? Or do we have a story that we're willing to actually tell? So they sent me not only to read all of their own documents, but to read the documents of other companies that made their documents publicly available as well through discovery. They sent me to reading the historians. They were paying me an absurd hourly rate at a big law firm, right, to do this work. But they thought that it was worth doing to know the history. And so as I applied my training as a historian to these boxes and to all of this body of work about asbestos, I developed a few ideas about what this history is. And I want to tell you a little bit about that today. As this article notes, one of the big differences between the third restatement's approach to foreseeability and the general approach of foreseeability law is whether this is a question of law versus a question of fact. The third restatement would turn foreseeability into a question of law. Whereas generally, foreseeability has been treated by the courts and in the common law as a question of fact, one that we would engage in individually for each case. We would ask for a corporation, who knew that asbestos was lethal and when? How much did they know about how little asbestos exposure you had to have for it to be toxic? We would ask when this knowledge common within this industry or within this particular corporation. Now, as Professor Bartlett mentioned, one of the interesting things that we should pause to note here is that the ancient Egyptians, the ancient Greeks, and the ancient Romans used asbestos. They knew about it, they incorporated it into their products, and, most interestingly, they also knew it was toxic. They understood that. They knew that, and in fact, in ancient Greek literature, the disease that was caused by asbestos was called the disease of the slaves. And it was called that because the slaves who wove asbestos fibers would die early of cancer. And they understood this. So, we have one option as an American society to say, hey, this knowledge is centuries old. We knew, as a human society, that long ago that asbestos was toxic. We could say that foreseeability, we could say it's a done deal. We could say that it's fair game to anticipate this knowledge from corporations. I, on the other hand, even though I'm a historian, would not like courts to say that I knew about something because it's in ancient Greek and Roman history. Because the chances are pretty darn good that I don't, right? And I would say most of you would agree with that too. What happened in the history of asbestos use was that it fell out of favor. It wasn't used, it wasn't that interesting. The knowledge really disappeared from human conversations because it wasn't terribly relevant. It still existed if you read ancient Greek history, but there just weren't a lot of people talking about it because asbestos use wasn't revived, as Megan mentioned, until the early 1900s. New industrialization and enormous growth in countries like the United States fueled asbestos as a new material because of its thermal properties primarily. New industrial activities needed the types of insulators that could go up to thousands of degrees and still not deteriorate. It still remains true, by the way, that our biggest use of asbestos still in the United States, NASA. Because we have still never invented anything else that can make it back and insulate our spaceships such that they can re-enter the atmosphere, the nose can become that hot and still not disintegrate, right? So we still use asbestos in this way. So the knowledge of the ancient Greeks and Romans was really rather forgotten for quite some period of time. the story of the distribution of knowledge about the toxicity of asbestos is actually a much more nuanced and interesting modern history. And unfortunately, what happens is that courts often talk about knowledge of, quote, the asbestos industry. Now that's a really problematic idea, because there really isn't such a thing as the asbestos industry. There was an enormous mining industry that brought out asbestos for use. But once asbestos was brought out as a raw product, it was incorporated into just about everything you can think of in America. It was put into electronics, ranging from radios to household irons for its thermal properties. It was put into automobiles in brake lining, tons of building materials, wall insulation, roofing shingles, wall coverings of various types, linoleum for floors. Pretty much every surface you can think of a house could potentially have asbestos in it. It was used in the automobile industry, in the brake linings, in heating systems, in also enormously in the American defense industry, within submarines and naval ships. What this means is that there in fact were a lot of industries that used asbestos, and it's nearly impossible to make a coherent and historically accurate statement about the knowledge of asbestos toxicity in the asbestos industry. Because the industries were highly distributed and they had different levels of knowledge at different points in time. Some of those industries understood very early on in the 1930s. There's really good evidence that other industries knew about 1960, and they didn't have good knowledge before then. If you think about it, part of what's happening is that some of these industries were using asbestos in tiny quantities, whereas others were using it in massive quantities. They had different rates of exposure to their employees, and they would have therefore had different rates of exposure in terms of take-home asbestos as well. While some information could be inferred from, say, publication of peer-reviewed studies in national journals in terms of that level of knowledge, it's also true that experts disagreed for a long time about important issues of causation for asbestos. Because of the huge latency period, exposure to asbestos, particularly for mesothelioma, it's often 15 to 25 years later before any symptoms develop. That means that causation can be difficult to track. And so for a long time, continuing through very recent years, experts who are very reputable in their fields have disagreed about how much exposure you needed for asbestos to be toxic. In other words, when it came particularly to secondhand claims, that really mattered, because they were not sure if that was enough. And interestingly enough, there were studies that were done in terms of autopsies of people who worked in asbestos facilities. Many of them would work there for decades. They would have many fibers of asbestos in their lungs when an autopsy was done, but they never died of an asbestos-related illness, and they died in their 70s or their 80s. So experts were really somewhat confused, because they knew that it wasn't the sort of thing like mercury, where we know that a tiny drop is going to really hurt anybody. The thing about asbestos is it was a little fuzzier than that. Some people were exposed for a long time, and yet they didn't seem to develop a disease. Other people were exposed almost none at all and developed mesothelioma 25 years later. So experts disagreed for a long time about what that causation mechanism really looked at. In particular, they disagreed about whether it was potentially a two-step mechanism. Did you have to have exposure plus something? Exposure plus genetic tendency, exposure plus exposure to another chemical, something along those lines. So even though there is early peer-reviewed information that suggested that asbestos was toxic, there's also early peer-reviewed information that suggests that it's not in a lot of circumstances. And when you look at what the corporations were deciding about using asbestos, the honest answer that you find in a lot of their correspondence is that they weren't sure, and they were seeking information. They were writing to other corporations and saying, what do you know? Do you have any in-house experts? What does your injury rate look like in your corporation? So what I really observed in looking through all of these records was a sense that causation was something that was that was determined differently in different industries. The automobile industry came much later to good knowledge about asbestos toxicity when compared to, say, the insulation industry. The U.S. government had very early information about the toxicity of asbestos. It did not give it to its contractors until much later. It did not provide that information to government contractors who were, for example, building those ships that Megan showed the pictures of a few minutes ago. So if experts disagree for all of these decades, from the 1930s through the 1960s, about to what degree there needs to be exposure to have causation, if this information, notably decades before electronic communication, is transferring slowly, and it's transferring in industry-specific ways. So you have automobile manufacturers contacting other automobile manufacturers, not thinking necessarily immediately to contact someone who is in the building industry, right? So you have information that's spreading through these slowly. In terms of the sociology, there are circles of knowledge. And those circles of knowledge are eventually intersecting, and we're developing a very broad, very thorough knowledge. But that happens at different times, and it happens in different spaces. And so I really in the end want to say that none of this is said in defense of the corporations, many of whom definitely, knowingly injured the American public because they had greater knowledge than the rest of us did as citizens, and they continued to produce products that contained asbestos and that were distributed to households across America. On the other hand, what I do want to say is that knowledge, as a historian, I can't tell you that there's a knowledge of the asbestos industry. If I were put on the stand to talk about this in a case, I couldn't say that the asbestos industry knew X or Y in the 1950s. Now, I could tell you what Ford and GM knew in the automobile industry in 1955, right? I could make a very specific statement about that knowledge. And because we think about foreseeability in terms of fairness, right? That's one of the big ideas behind foreseeability, that we want people to be able to feel like that we fairly anticipated for them to know that they had a duty. Then it makes sense to me to tie that to localized solutions. If you think about it in this way, for example, here in Virginia, we are less likely by far in older buildings to encounter asbestos than you are in Connecticut, than you are in New Hampshire. You know why? Because we don't often get temperatures in the negatives here. While asbestos is used and has been used as far south as Florida, it's much more rarely used and was much more rarely used in the southern areas. Knowledge of asbestos toxicity was much more prevalent in the Northeast, substantially before it was prevalent in the American South, because these industries had a geography of the distribution of information. As a historian, because I don't want to make those big statements about the asbestos industry knowing something at a particular time, I think Megan's solution makes a great deal of sense for each individual state legislature or state court system to think about this specifically, to determine what the level of knowledge was for an individual state. And maybe a state where the automobile industry exists or where the insulation industry exists, it makes a great deal of sense to me that they might even want to state something in a statute about foreseeability and specific and prevent the courts from having to engage in an individual historical application of facts. But I don't think that a national solution works very well for exactly the same way. If we really want to think deeply about foreseeability, and if we really want to tie foreseeability to fairness and to a fact-based historical question, then the answer is going to be slightly different for different areas of the country and for different industries. States and state courts are in a position to tackle those questions in a way that I think that Congress is not, without making the kinds of statements that are going to ultimately be untrue. So even though in the end what Megan had to say was, it depends in a sense, because she has kicked this question somewhat to the state legislatures and through this multi-factor test that maintains foreseeability, I think she's very right in saying it depends. Because if we want to think about foreseeability in terms of history and fairness, the answer is unfortunately still, it depends.
an exceptional treat. I think you were just in for 2 hours of fabulous analysis, commentary, thought. I think, and I am certain you all agree with this, this has been an outstanding afternoon. 2 exceptional third-year students who are members of, I have to say, an exceptional law review board, and a fabulous group of people have been joined today by 2 distinguished commentators, and obviously an engaged audience. And I'd say Megan and Kyle have done all of us incredibly proud. They should be an inspiration to all of you, in fact, to all of us. And I have to say that thinking that they will soon join the legal profession gives me, and I think it should give all of us, a lot of hope for the future of the profession. I want to be particularly mindful of our 2 outside commentators, Professor Bartlett, for whom this is clearly a homecoming, and Professor Grummelman, who have obviously put a lot of thought into their commentary. And I appreciate all of their effort in their reflections and in the encouragement that they have provided to both Kyle and Megan. Professors Fraley and Wyand, and I know I was looking the opposite way, have given us further food for thought. And I say we appreciate not just the efforts they've put into this afternoon, but all the efforts that we know they've put into these thoughts and into these 2 students. As Megan has told us, Professor Fraley is partly to blame, I think, why she is up here this afternoon. My gratitude also goes to the note advisors, Professor Seaman, Professor Murchison, Professor Yost. 2 of them have not only provided lovely introductions, but more importantly have been guides, mentors, and promoters of our students throughout this entire process. Of course, I'd be remiss if I did not thank the Law Review, its members, and their advisor, Professor Brunner, for their ongoing efforts in putting out a first-rate journal that contributes to the ongoing development of legal thought and process. And last, but surely not least, I think we all have to be grateful to the Law Council, who are ultimately responsible for bringing us here together this afternoon. It was their initial idea of initiating this annual event. And as Professor Brunner said, this is one of the most featured and exciting and I think inspiring parts of the academic calendar. So I want to thank them for having provided us with the impetus to celebrate the achievements of law review, of our students, and our faculty. And it clearly shows a deep appreciation of the scholarly enterprise. I want to close by thanking you all for coming this afternoon, and have a wonderful evening. Thank you.